If you've been hit by a truck, an 18-wheeler, a semi-truck, a tractor-trailer, a box truck delivering for Amazon, UPS, or FedEx, or a dump truck, you don't have a car accident case. You have something much bigger. And if you hire a lawyer that treats this trucking case as a fender bender on the interstate, well, you're going to lose evidence that you cannot get back. Not just any lawyer, not even a personal injury lawyer that advertises on TV. You need a trucking lawyer. Someone that knows the federal motor carrier's safety regulations. Someone that understands how to chase down black box records, telematic records before they disappear. And knows not to just go after the driver, but the motor carrier, the shipper, the broker, and everyone else that had a part to play in putting that truck on the road. Trucking cases live and die on details most lawyers have never even heard of. So you need someone who has. My name is Asthana from Caldwell, Wenzel, and Asthana Personal Injury Lawyers. We handle serious injury cases across Alabama, Mississippi, and the Florida Panhandle. And a big part of our practice is serious trucking accident cases. Today, I want to walk you through exactly what makes a trucking case different. A passenger car weighs about 4,000 pounds. A loaded 18-wheeler, well, that weighs about 80,000 pounds. A truck that size needs about the length of a football field to stop at a highway speed. It has blind spots on every side, including in the front of the cab. And the driver is supposed to operate that truck with a different set of rules, different from even the ones that you and I follow. Those rules are called the Federal Motor Carrier Safety Regulations. They cover hiring, training, supervision, drug testing, hours of service, vehicle inspections, and record keeping. And here's what matters. Those regulations are about the floor of what a trucking company is expected to do. They are not the ceiling. When a serious truck wreck happens, the questions are not just whether the driver made a mistake. The questions are, why did this happen? Was it preventable? How could it have been prevented? And who could have prevented it? So this is where most people are surprised. The driver of the truck is usually not the only defendant in a trucking case. A real investigation also looks at the motor carrier, usually the company advertised on the truck, the broker that arranges the load, the shipper, the maintenance shop, sometimes a parts manufacturer if a safety system fails. A very common trick that we see in trucking cases is where the motor carrier claims that the driver is not an employee of the carrier, but an independent contractor. Under federal law, that defense often doesn't hold up. When a carrier leases equipment under 49 CFR Part 376 and the truck is moving under their federal authority, that driver is treated as an employee of the carrier for safety and liability purposes. And that is decades of federal law. Some of the largest carriers in the country have paid hundreds of millions of dollars settling cases that turned on this issue. Federal law also requires for-hire motor carriers to carry a minimum of $750,000 in coverage. And for carriers that are carrying hazardous materials, that minimum coverage could be a lot higher. And what most injured people are never told is that sometimes a single serious crash can tap into more than one of the insurance policies that are available. One of the most important things to recognize in a trucking accident is that clock. It starts to run the moment the wreck happens. Modern trucks, they record an enormous amount of data. Engine-controlled module downloads, electronic logging device entries, telematics from systems like Samsara or Lytx, which can include speed, braking, lane drifting, and dashcam videos. There are also satellite GPS records and dispatch messages, hours of service logs, drug and alcohol testing records, and the driver's qualification file. A lot of data that has short retention windows, some of which can get overwritten within days. Some of it that can lawfully be destroyed within 30 days of the wreck unless someone tells them to preserve it. That formal notice is called a spoliation letter, and that letter, it needs to go out fast. And that is one of the first things we do on a new trucking case. We send a preservation letter. We pull the federal safety measurement system data on the carrier. We submit Freedom of Information Act requests for the official crash report, also called a FOIA request. We inspect the truck at the scene where the physical evidence still exists. If a client comes to us 6 months after the wreck, we're already behind. If they come to us right away, we are right in front. There's one more reason a trucking case is different in the state of Alabama than almost anywhere else in the country. Alabama follows a pure contributory negligence rule. It means if the jury finds you to be even 1% at fault in causing the accident, you are barred from making any recovery at all. So the first call after a serious trucking accident is almost always designed to get a recorded statement to find that fault. It's to get you to agree that you were too tired, sleepy, distracted, or perhaps driving too fast for the conditions. Anything at all that they can point to argue that you contributed to the accident. In most of the other states, that argument only reduces the amount of your recovery, but in Alabama, it guts your case. No recovery at all. And that is precisely why we ask people not to give a recorded statement to the trucking company's insurer before they have spoken to a trucking injury lawyer. Even if you feel fine, even if you think you have nothing to hide. That conversation is intended to build a defense against you. It's not to help you. Now, if you're in the Florida Panhandle, like Pensacola or Panama City, the rules are different. Florida follows comparative fault, which means that even if you are partially responsible for causing the accident, you can still make a recovery. The insurance companies there use different tactics. Their goal is to show that you were more than 50% at fault in causing the accident. Those tactics still remain very aggressive. The evidence still disappears on that timeline. The federal regulations still apply. And you still need a lawyer that understands trucking law, not just a car accident lawyer. Mississippi follows what's called pure comparative fault, which means that even if you were 99% at fault in causing the accident, you can still recover that remaining 1%. Mississippi trucking cases, like anywhere else, are still aggressively defended. The evidence still disappears, and the federal regulations, they still apply. And the trucking companies and their insurers are still going to come after your statement even before you've had a chance to speak to a trucking lawyer. That standard being somewhat favorable to you does not mean that the fight is easy. So if you or anyone you love was hit by a big commercial vehicle in Alabama, Mississippi, or the Florida Panhandle, here's what I want you to do. Get medical care and follow through with it. Do not give a recorded statement to the trucking company or their insurer before you've had a chance to speak to a trucking lawyer. Save everything that you have from the crash and call a firm who actually handles trucking cases. Caldwell, Wenzel, and Asthana has offices in Foley, Birmingham, Mobile, Pensacola, and Jackson, Mississippi. We handle the investigation, the federal records requests, the preservation of evidence, and all of the litigation start to finish. Our consultation is always free. You pay nothing unless we recover for you. Your case deserves to be built on evidence, not buried by it. So give us a call. We look forward to working for you.